Hello, my name is Chelsea James. I am presenting to you the Choctaw Nation of Oklahoma Tribal Court System presentation today. The Choctaw Nation of Oklahoma is actually very interesting how their tribal court system works. They have a very in-depth and professionally ran court system, all the way down to their treaties for the tribe. The first treaty that comes to mind when you think of Choctaw of Oklahoma is actually the Treaty of Hopewell, 1786. This one relies on the peace to all Choctaw Nation and that the United States offered protection for them under certain circumstances. And those are listed in the next four articles that stood out to be the most important. Article 1, the commissioners of all Choctaw Nation were to restore all prisoner citizens or subjects of allies of the United States to their entire liberty. Basically, they were to forfeit them. Article 2, the commissioners of the Choctaw Nation, they acknowledged what they called the nation, which referred to as the tribes and towns of the allotted lands and were within the boundary. They could live and hunt and be under the protection of the United States and no other sovereignty. Article 5, if an Indian or a person living on land committed a robbery, murder, or capital crime of any citizen or someone under the protection of the United States, then the tribe, or if it was a said nation of the offender belongs to, then it shall be delivered and punished in accordance to the United States in Congress Assembly. So that provided that the punishment shall not be greater than if the robbery or murder was basically done outside of the boundaries from a U.S. citizen to another U.S. citizen. Article 7 is understood that the punishment of the innocent under the idea of retaliation is just unjust. That is not okay with any of them, and that is not allowed. So those are the main parts of the treaty that stood out the most and are still pretty much applied to this day, and how the rest of the treaties were shaped and created of some sort. So the Choctaw Nation has their own constitution, and under this constitution they do have a preamble followed by articles, sections, etc. What stood out the most in the preamble was the fact that it was based off of several main factors. They wanted to provide guidance. They wanted to promote general welfare to their people. They wanted to ensure that there was a tranquility within the community. The prosperity of blessings of ancestral heritage was huge and very important. The culture and customs for them is very important. And then the tribal sovereignty as well. So among the articles of the Constitution, the Choctaw Nation, specifically Oklahoma, the ones that stood out the most pertaining to tribal courts included Article 5, and in there, the division of power of the government was under Section 1, which stated that there's actually three departments. There's executive, legislative, and judicial. Article 6 then stated that under the executive department, Section 1, the supreme executive power of the nation will be considered the chief of the Choctaw Nation. So under Article 7, it was privileges, duties, and powers of the executive department. Section 1 stated that the chief performs all the duties appertaining to the office of the chief executive. Section 4 was also relatively important to tribal courts, as it was the chief has the power to veto any legislative act, rule, or regulation of tribal council. Under Article 8, the legislative department, Section 1 was legislative authority, and that was vested in the tribal council. Article 9, privileges, duties, and powers of legislative department. This was under Section 7. Tribal council shall sit as court in all cases of impeachment, which is relatively important as compared to traditional courts. Under Article 9, Article 9, Section 9, the majority of the vote for implementing or approval, that came from the 7 members of tribal council as well. Section 10 was tribal council has the right to override the chief's veto of any actions, but at least 8 members have to be voting in favor of overriding the veto for that to take place. Under Article 12, under the judicial department, Section 1 states that the judicial authority shall be vested in tribal council and will consist of 3 members of the court that are appointed by the chief. Article 13 was under privileges, duties, and powers of the judicial department. Section 1 was that there's exclusive power under the jurisdiction, and that decides disputes. Section 2 refers to the rules of procedure of tribal court shall be prescribed by tribal council to ensure members' due process of law. And Section 3 is that the decision of the tribal court shall be final regardless. So the Choctaw Nation judicial system overall didn't officially start until later on, but they did have a system for justice starting back in 1820. The Choctaw Nation had tribal leaders in central Mississippi that signed a Treaty of Doak's Stand, which led to the Choctaw people being removed and led to Oklahoma. So the Choctaw Nation court system was implemented in 1832, but it wasn't until 1838 the Choctaw reestablished their government by adopting a new constitution. This was created by the chiefs for 3 districts that were formed, and they included the executive branch, legislative branch, which was by a representative council, and a judicial branch. The court systems continued to deliver a sustainable and overall justice for the citizens. And as the Choctaw Nation has grown, the judicial branch has grown as well. This created a judiciary process that is dedicated to creating fair justice with integrity and compassion. So in 2009, the general jurisdiction was to unite and consolidate the nation's courts. This was to replace the CFR Court of Indian Offenses. The Court of General Jurisdiction now operates through the Appellate Division and the District Courts of the Choctaw Nation. In 2009, the Choctaw Nation Tribal Council determined that the administration of justice and the general good of the Choctaw people would be best served through unifying and consolidating the nation's courts to a unified judicial department. This was to operate through Appellate Division and the District Courts of the Choctaw Nation, and the Court of General Jurisdiction has full civil, criminal jurisdiction over the Indian country and was described in Article 1, Section 2 of the Constitution. So the Court of General Jurisdiction also should not have jurisdiction over matters arising under any provision of the Constitution or under any general regulation or rule that is enacted by tribal council. The Choctaw Nation District Court currently consists of 2 district judges and 1 special district judge, which may be appointed according to law. The court also presides over criminal matters in accordance to the Tribal Law and Order Act adopted into the Choctaw Nation in 2015, and that is for the nation's district court. And then the court is designed to assist the Choctaw people, but it will accept others into the court upon execution of certain waivers. So the current tribal court laws for the Choctaw Nation is overall governed by the Choctaw Nation Constitution, and this provides an executive, legislation, and judicial branch, as I stated before. The legislative authority of the tribe is vested in the Tribal Council, which consists of 12 members. The judicial branch, the Choctaw Nation Judicial Branch, is dedicated to providing both Choctaw citizens and tribal members with a simple, fair, and efficient judicial system and due process. The new Judicial Center represents the pinnacle of that promise that was built in 2019. In 2021, a very important court case called Sizemore v. Oklahoma issued a ruling, and that was through the Oklahoma Court of Criminal Appeals. This was declaring that the Choctaw Nation Reservation was never disestablished. The decision was long awaited for the U.S. Supreme Court's landmark ruling that McGritt v. Oklahoma case, which a lot of us are familiar with, which was decided in 2022. The McGritt ruling determined that Congress never disestablished the Muskogee Creek Reservation when Oklahoma became a state in 1907, and that McGritt should have actually been prosecuted in federal court. Another important factor of this McGritt case was in 1885 Major Crimes Act, which is a federal law dictating the major crimes involving Native Americans in Indian country be prosecuted in federal and tribal court. And that was stated in Title 18, Section 1153 of the United States Code, which is known as the Major Crimes Act. This grants tribes and the federal government exclusive jurisdiction to prosecute certain enumerated offenses that are committed by Indians within Indian country. Now, to date, the Choctaw Nation has actually reviewed more than 500 cases, and those are involving self-identified Native American defendants from the state of Oklahoma, with a focus on incarcerated defendants.
This landmark decision made national headlines and has sparked both concern and interest. The reality is that sovereign Indian nations with treaty rights and land-based treaty territory, yes, reservations, have existed long before Oklahoma became a state in 1907. The McGirt decision affirms that those reservations still exist today and upholds the Major Crimes Act regarding crimes committed by Native people in Native territory. What does this mean for the Choctaw Nation and southeastern Oklahoma? First, remember that this decision directly addresses the Creek Nation's reservation and criminal jurisdiction. Nothing has immediately changed for the Choctaw Nation or southeastern Oklahoma. McGirt does not change individual property ownership, business taxation, or any citizen's responsibility to uphold the law.
So you can actually find 2 locations for the current tribal courts. The new Choctaw Nation Judicial Center is located in Durant, Oklahoma. It opened in March 2019. This was designed to pay tribute to the look of the original council house, and the Judicial Center is fully modernized with the latest technology and security, and it actually houses 3 courtrooms, offices for justices, court officials, and associates, and it has additional rooms for new and existing programs that the judicial branch might include. So the Choctaw Nation has a constitutional court. This has exclusive jurisdiction that will decide disputes arising under any provision of the Choctaw Nation Constitution or any rule or regulation that is enacted by the Tribal Council. They also have supervisory authority over the Court of General Jurisdiction and discretionary authority to hear an appeal from any judgment from the Appellate Division of the Court of General Jurisdiction. And under these rules, as the Constitutional Court, they shall adopt it, with the approval, of course, of the Tribal Council. The decision, though, of the Constitutional Court shall be final. Now, there are 1 Chief Justice, known as David Barrage, and 2 tribal judges. There's Mitch Mullen and Frederick Bob. And the core focus of it is the beliefs of family, culture, and faith as the Choctaw Nation's constitutional core. Now, they also have a national district court, and this is to provide support and service to the Choctaw family, and the mission is to always seek the best interests of the children. So the Choctaw Nation Court actually consists of 2 district judges, Mark Morrison and Amy Pierce, and 1 special district judge, which is Richard Branham, and these are appointed according to law. All decisions made in the district court will be recognized by the state and CFR courts. The district court also focuses on family issues such as divorce, child custody, child support, parental rights, visitation and adoption, civil matters, juvenile matters, and guardianship. The court also presides over criminal matters in accordance to the Tribal Law and Order Act, adopted in Choctaw Nation legislation in 2015. The Appellate Court Division is the jurisdiction exercises appellate jurisdiction for cases appealed in the district court. The court's primary function is to review and procedures and decisions to ensure the proceedings were fair and proper law was applied correctly. The division also has full authority over an appeal from the district court to affirm, reverse, and modify or vacate any action in the district court or other entity from which an appeal is taken as authorized by law. Now, they also have 2 appellate judges and a presiding judge. The 2 appellate judges are Bob Rabin and Warren Gotcher, and the presiding judge is P.L. Peyton Phelps. Now, there's also a trial prosecutor, which is Kara Bacon. She is in the office of the Choctaw Nation Trial Prosecutor and represents the Choctaw Nation in all criminal, juvenile delinquent, and juvenile deprived matters. So if you're a victim in a case and have a question, then they have a victim witness advocates list, and that's who you would contact. If you're in a defendant and you're calling for a criminal defendant, then you'll speak to your attorney or representative public defender's office, and they have it really clear actually on the page on how to approach all of that, which is really awesome. So I was able to locate court cases that were post-McGritt statistics under Choctaw Nation. The list of them included the felony cases, misdemeanor cases, juvenile delinquent, juvenile deprived, traffic, special domestic violence jurisdiction, civil cases that were filed, general civil, adoption, paternity, divorce, guardianship, and protective orders. These are all cases that were filed within Choctaw Nation, and that was after the decision on McGriff.
Breaking the cycle of social ills in a family isn't easy, especially when those problems span multiple generations. But I truly believe by offering alternatives and wraparound services in our judicial system, we can make a positive difference for our tribal members and our communities. Until next time, Chipisa La Chiqui.
So Choctaw Nation actually does have the Peacemaking Act, and they do actually have overall jurisdiction. They use it. A couple of sections that stood out that were actually very important for tribal courts was actually Section 4, which was jurisdiction of the peacemakers, and they have jurisdiction over any matter referred to by the District Court of the Choctaw Nation of Oklahoma if all the parties that are disputing that are to dispute agree to be bound by the decision of the peacemaker. So if a peacemaker determines that the peacemaking process cannot produce an agreed resolution of the matter, then they transfer the case back to the district court and will resume jurisdiction over that case. Section 13, an order entered pursuant to this act will be enforceable in the same manner as other orders of the District Court of the Choctaw Nation of Oklahoma. And then Section 17 claimed that a peacemaker is permitted to use any reasonable process or method of working with the parties to resolve their dispute if force, violence, threats, or compulsion is not used. The basic rights of the parties shall be respected by the peacemaker and all parties during the peacemaking process as well. They can use cultural and traditional customs as well when they are making these decisions.
Judge Pierce and I were enjoying our visit so much we decided to stick around and talk about some of the unique opportunities the Choctaw judicial system has for tribal members, like Peacemaker Court and our Health and Wellness Court. Well, I know, Judge Pierce, you were talking about our Peacemaker Court, kind of bringing the cultural side of that, and about Health and Wellness Courts. Do you mind explaining all about that?
Sure. So the Health and Wellness Courts, what most people are used to it being referred to, at least in the state system, is a drug court. But a Health and Wellness Court is really, it's a step above and beyond that. A Health and Wellness Court, its goal is to create a treatment plan for the whole person. So you bring that person kind of to the table and you see if there are other programs and ways to assist them to break the cycle of abuse. So it isn't just pulling someone in and saying, here's a treatment abuse plan, go on down the road and see if you're successful. It's really monitoring them, it's treating the whole person, but at the same time incorporating our traditional Choctaw values into assisting that person to see if there's a way to help them break the cycle and to be a productive human being.
And when you talk about cultural values, we hear all different types of things on what that means. What does that mean to you?
So to me, a traditional Choctaw cultural value means several different things. It does mean family, and to me, and I'll show you this is my locket, and these are my Choctaw grandmothers here. This is my Ma Smallwood and my grandmother, Beverly Honeywell. Their traditional Choctaw values that they taught me were really to listen to the other person, to see what their problems are, and if there's any way that you can assist them with their problems, then do so. I think that is a true Choctaw value, is the need to take your faith, to take your family, and to try to assist others within that circle to see if there's a way to help them resolve their problem.
So the Choctaw Nation of Oklahoma does have a bar association. They do have dues of $50 that are annual. They have an application for admission to the Choctaw Nation of Oklahoma Bar Association. They also have rules, code of ethical conduct, and judicial canons. The requirement for it is that any person shall be authorized to practice as an attorney and counselor at law in any court of the Choctaw Nation who has been admitted to the bar of the Choctaw Nation of Oklahoma. They must possess good moral character, due respect for the law and fitness of the practice law. They must be at least 18 years of age and is an attorney at law and is admitted to practice before the highest court of any state of the United States and is a member of good standings of such bar or has been licensed by the Oklahoma Supreme Court as a licensed legal intern. But all interns must comply with the provisions of Oklahoma law while practicing in the courts of the Choctaw Nation.